BAC from the CFST for the recommendation on the final tender. And you'll recall that although Lufthansa was the cheapest bidder for the final tender, CFST recommended not to go with Lufthansa. Do you recall that?
Initially, Chair, the CFST recommended to go with Lufthansa. Yes.
And then by the time they make the final submission to the BAC, as I understand it, they were then recommending Air France. Is that right?
Okay, Chair, let me explain how the process works at SAT. SAT being the technical part of SAA. Remember, I explained that for BAC, they go for BAC for notification. Sometimes they could go even afterwards because it's just for notification, not for approval. So it went to the board, and the board, because there was, they questioned why it didn't go to BAC, and then apparently there was no one who understood that part where it said to the BAC it just goes for notification, and then the board said, okay, take it back to the CFST. Yes, and then it must go back to BAC. But like I think they raised also concerns about like why would CFST recommend and management of SAT recommend Lufthansa based on the lower price and the fact that they were not committing to supply development. Yes.
Ms. Miller, I'm now talking about May 2016,
yeah,
when on the 4th of May there's a submission to the BAC, and then that's followed by the acting CEO's submission to the board for their meeting on the 9th of May.
Yes.
And as you've pointed out previously in your evidence, although CFST originally identified Lufthansa as the preferred bidder and the one who should be awarded the contract, there were certain reservations that they expressed about Lufthansa. Do you recall that?
I recall that.
And what I want to know is you attended a CFST meeting in the lead up to that in April, correct?
I attended the CFST in there?
A meeting, it was in April.
April. Can we...
That's the one where it records that you joined the meeting and you stressed the urgency of the decision that needed to be taken, and you were there to provide guidance. Do you recall that?
Okay, so yeah.
Okay, so all that I'm wanting to glean from you is the reasons for not going with Lufthansa. We see those from the BAC submission, and we see them later in the CEO's submission.
Okay.
And the one that I just want to pick up on is there was a concern raised that Lufthansa still had outstanding NIP obligations. Do you recall that as being a reason for not going with Lufthansa?
From the board?
No, this is from, now CFST is doing their submission to the BAC, and then that is taken as the submission by the CEO to the board. And in both of those submissions, which are virtually identical, the point is made that amongst the problems with Lufthansa is that the bidder still has outstanding unresolved NIP obligations. Do you recall that?
Okay, can you direct me to the document?
Yes, certainly.
Okay.
It's at DD 22F, DD 22F, and it'll be at page 2294.
Page?
2294. Just to orientate you, Ms. Mamela, this is a page within the submission that was prepared by Leon Robertser for the BAC. Mm-hmm. Okay. And the page I'm interested in is the one at 2294, because you'll see that page, they've dealt with the scoring and they've set it out in the submission. And now we get to page 2294.
Yeah.
And it says the following at the top of the page. Based on the above scoring tables, Lufthansa has quoted the lowest price. But due to the risk highlighted below, the CFST recommend the bid be awarded to Air France Industries, subject to successful contract negotiations. And then there's another line, risks identified with the tender would be defined as follows. And there's a heading for the risks identified for JMAAR, and then there's a heading Lufthansa. Okay, and it's the second bullet that I'm highlighting there.
Oh, okay.
The issue raised as a risk with Lufthansa was that the bidder still had outstanding unresolved NIP obligations from a previous tender. Do you see that?
I see that.
Yes. Was this something that was discussed at that meeting that you attended in April with the CFST?
On the NIP obligation?
Yes.
The NIP obligation, I would believe that, Chair, it was the knowledge of everybody at supply chain, because what Lufthansa was the previous supplier, competent supplier of SAT, and they have never adhered to NIP obligation. As I had explained, that it is actually managed by the DTI, and then also I think because the final tender was the one that included the supply development.
But can you remember whether it was discussed at the meeting?
I wouldn't remember, Chair.
You would not remember?
I wouldn't remember, yes.
But you're saying everybody was aware?
Everybody was aware of
Their situation on this point?
their reluctance into anything that has to do with transformational agenda. Because even on the final one, they did not want to commit on the supply development.
Okay.
Yes.
But supply development, as I understand it, is different to the NIP obligation. That's why I was concerned to pick this up, because your evidence yesterday was that the NIP obligation had nothing to do with this final tender, because there'd been a decision to replace the NIP obligation with a supplier development obligation. If that was your evidence, why would Lufthansa's previous performance under a NIP obligation be relevant to this tender at all?
Chair, I want to explain again my testimony yesterday with regard to NIP.
Yes.
I explained to Ms. Hofmeyer that there is direct NIP and indirect NIP. They are both NIP, but the supply development falls under indirect NIP. So it's still NIP regardless. And also both these elements are still under transformational agenda of this country. Yes.
Did anyone actually find out whether Lufthansa had complied with its NIP obligations?
I remember, who's this? The GM operation at that time, Chair. We had gone to DTI with them and HOD workshop, because we wanted to find out with regard to certain other contracts with Lufthansa other than that previous one, that they had adhered to the NIP obligation. But at that time, there was just like some disagreements between them and the DTI. As I said, that it's always a relationship between Lufthansa and DTI. Sometimes these multinational companies, they understand to have adhered to the NIP obligation, only to find that like how it is explained by the DTI, it's not what it was supposed to be. Yes.
You see, the DTI has given an affidavit to the Commission, it's the one that we looked at yesterday, in which they've confirmed that Lufthansa was never non-compliant with its NIP obligations. Do you have a response to that?
Can you go to that affidavit for when?
Yes, certainly, since 2013. I'll give it to you, it's at Exhibit DD22G.
Since 2013, Lufthansa in 2013, Chair, so that we don't waste time, Lufthansa in 2013 was not the supplier service provider for component tender.
No, the point that I'm making, you said for what period had they not been non-compliant? In other words, for what period had they been compliant? According to the DTI's affidavit, I'll read it to you. It's in 22G at page 2977.
Page? 29?
2977.
I'm here, Chair.
So what the Director General of the Department of Trade and Industry, Mr. October, says at the bottom of that page in paragraph 27 is the following. I should also place on record that Mr. Kirtland, that's a reference to the Commission's investigator, requested information in relation to Lufthansa's performance of its duties flowing from the obligation agreement which was entered into between the DTI and Lufthansa. The agreement was signed on the 17th of February 2013 and is attached here to marked Annexure I. According to the DTI's NIP records, there is no indication that Lufthansa is non-compliant in relation to its current NIP obligation. In this regard, I've attached here to a printout of Lufthansa's performance status as at 30 September 2019, and he attaches that as an annexure. He goes on and says, the DTI has never received correspondence from SART in relation to Lufthansa's non-compliance with its current NIP obligation.
Chair, I think maybe there is a misunderstanding with regard to the interpretation of Ms. Hofmeyr or maybe Mr. Kirtland and Mr. Human. In 2013, Lufthansa was not the service provider of component for SAT. This tender that you were talking about, like their non-compliance with NIP obligation, it was specifically referred to that tender. Remember, Lufthansa may have had other contracts at SAT that have nothing to do with component services. So they might comply.
They might have been compliant in regard to other tenders.
Yes, yes.
No, then I don't understand, because I understood you to say that a reason for not recommending Lufthansa was that it had outstanding NIP obligations from a previous tender. That's what was recorded.
Previous component tender,
No.
not the other, not the other services.
No, but what previous components tender had Lufthansa been awarded?
Okay, like, Chair, remember there is a commitment that all the suppliers should make when they respond to the tenders. With regard to the NIP obligation, there is a form that they're supposed to fill in to commit to NIP obligation. So it was actually referring to that previous tender for the component. Remember, the component tender started from 2013 up to, it was finalized in 2016. So Ms. Hofmeyr, referring to the affidavit of Mr. October, yes, like that, whatever that is confirming has nothing to do with component tender. Yes.
Ms. Mamela, I do have to just conclude this point. Lufthansa submitted a compliant bid for the final components tender because they were not disqualified. Amongst the requirements in the final components tender was the filling out of the SBD5 form that we looked at yesterday. So they had fully undertaken to comply with the NIP obligation for the final tender. Indeed.
There was no NIP obligation.
Let her finish, Ms. Mamela.
What is recorded here is that the bidder still has outstanding unresolved NIP obligations from a previous tender.
Yes.
Indeed. But that tender was never awarded.
Yes.
But then I struggle to understand, because there could never be a NIP obligation that was undertaken in respect of a tender that was not awarded.
Chair.
I think Ms. Hofmeyr is saying to you, and Ms. Hofmeyr, you will listen and you will tell me if I misunderstand your question.
Okay.
I think her point is, if Lufthansa was compliant in regard to the NIP obligation or undertook to comply with that obligation in regard to a tender that was being looked at that time, it's difficult to understand why they would be disqualified or they would not be given a tender simply because in the past there was a tender in respect of which they did not comply. Ms. Hofmeyr, is that
Indeed,
is that
Chair.
right?
If I may say far more eloquently than I put it.
Were they disqualified for not complying with the NIP?
No, the point, Ms. Mamela, is that the final tender, the one that CFST was evaluating in April of 2016, had a requirement that you had to undertake a NIP obligation and you had to, with your bid submission, sign an SBD5 form. And all of these bidders, Lufthansa, JMAAR, Air France, complied with that. So in their bids for the final tender, they submitted the SBD5 form. That is why when CFST records this, they don't talk about this tender. They say the bidder still has outstanding unresolved NIP obligations from a previous tender. And I understand you to say your understanding of that was that one of the previous components tenders that was never awarded, they might not have submitted an SBD5 form. Is that your understanding?
My understanding, Chair, was that since Lufthansa was the previous component tender of SAT before Air France, they had never adhered to the NIP obligation as required in the past.
But
that would be my understanding of what is written here.
Yes.
I don't know what is the understanding of Ms. Kate, but I was still going to ask her to direct me to the agreement that she said it was the attachment to the...
Okay, before that, let's just make sure we understand the basic information.
Yeah.
Do you accept that in regard to the tender that Ms. Hofmeyer, that we are talking about now, in regard to that tender, do you accept that Lufthansa was compliant or undertook to comply with the NIP obligation?
I wouldn't know, Chair.
You would not know?
No.
And do you, or have you come across anything that suggests that CFST at the time thought that Lufthansa was not compliant in regard to the NIP obligation in regard to the tender they were considering?
Not on the tender they were considering, Chair.
Yeah, only the previous
On
one.
the previous contract that they had with SAT, because remember,
Okay.
the NIP obligation started long time ago.
Yes,
Yes,
okay.
and Lufthansa was the previous
Yes.
component support, supplier of SAT.
Yes.
Yes, before Air France.
Now, well, my question, and maybe Ms. Hofmeyer's question, is why would they, if they were compliant with regard to the NIP obligation or undertook to comply in regard to the tender that was being considered,
The final one.
the final one, why would the fact that sometime in the past in regard to another tender they might not have complied, why would that be used against them?
My understanding is that, because the final tender, the 2016 one, required all the multinational suppliers to bring their commitment towards the supplier development. And my understanding will be that Lufthansa did not bring the commitment like other multinational companies, like Air France brought in Kwane Capital, H.A. Walters brought in Pegasus.
I'm sorry, I don't want to, I'm not sure that I understand. I think we are on the same page.
Yeah.
That with regard to the final tender, you have not come across anything that says Lufthansa was not compliant. You are not aware of anything that relates to them not having been compliant in regard to the final tender. You are aware of a concern that sometime in the past, sometime before
this tender, yes.
they were not compliant.
Yes.
So my question before I speak to Ms. Mbandwa is, I'm not sure that I would understand why the fact that sometime in the past, in respect of a previous tender, they might not have complied, and it was not awarded to them, why that would be used against them in regard to the final tender.
I guess, Chair, it will be used based on the fact that SAT and SAA that time was driving a national transformational agenda. And NIP is part of the transformational agenda.
So even if they were compliant at the moment, so to speak?
I'm not sure. I'm still going to ask Ms. Hofmeyer
Yes.
if they were compliant on the 2016 one.
Yes.
But from what I was reading, what was written there by the CFST, it said, about supply development. I don't
Okay,
think they will,
she will address your concern. Ms. Mbadwa, has your concern fallen away?
No, this is not an objection, Chair.
Yes,
Just
yes,
for me to be able to follow. I
yes.
wanted to know if, because I hear Ms. Memela saying Lufthansa was previously,
Non-compliant.
was previously the supplier for the components tender. I want to clear that, or is it not like that?
Oh, I didn't understand that. I think
Yes, because that is where,
I think leave a note for Ms. Hofmeyer, but my understanding is that it was not, Lufthansa was not compliant in regard to the NIP obligation, but that tender for which it had put in a bid was not awarded. Is that fine, Ms. Memela? Okay, we'll clarify it, Ms. Mbadwa. Are we confusing you?
I'm so confused.
Chair, if I may assist.
Yeah.
Because Ms. Mamela, first of all, asked, could she be taken to the agreement?
Yes, the one that we're
between
talking about.
Lufthansa and the DTI? Because, in fact, it is an agreement related to SART and component support. So let's go to that. It's in DD 22G, and it's at page 3124. Apologies, the first page is 3123.
I'm sorry, did you change the page number?
3123, Chair.
3123.
Yes.
Okay.
Chair, just to orientate ourselves, what Mr. October had said in his affidavit was he'd been asked by the Commission's investigators whether Lufthansa was non-compliant with its NIP obligations. And he'd gone back to the records and he found the agreement that was entered into, and you see that at page 3123. It's between the Government of the Republic of South Africa and Lufthansa in broad terms. And if you turn over the page, it tells you what contract this is in relation to. That's at the top of the page. It says, whereas the obliger, that's Lufthansa, has been awarded a contract for the maintenance, classic power by the hour, and cost per event, PBTH, of, and then it's a series of an engine, operated by South African Airways and or maintained by South African Airways Technical from time to time. Currently this numbers 39 engines. Contract reference, and then it's got the SART reference. And it says it was entered into in writing on the 23rd of July 2013.
Yeah.
So I understand Mr. October's evidence in his affidavit. He says this agreement was in force at the time that the 2016 bids were being adjudicated. And according to the DTI records, Lufthansa was fully compliant. He attaches the schedule to that effect, and he says that there was no respect in which non-compliance had been raised in writing with the DTI. But does that assist, Ms. Mamela?
Chairperson.
Yes.
Ms. Hofmeyer, I don't know, maybe she does not want to listen to my explanation. Before she read this agreement, she said, at different times we are all getting confused at some stage or another. So okay, Chair. She had said, I said that has nothing to do with component tender. And she said that actually has everything to do with component tender. This agreement is an engine agreement. It's not the component tender agreement. So I don't know how I explain this. Like I said, I'm saying it does not matter how many contracts.
Well, you did make the point earlier that
so I'm
you were
explain.
referring to the specific component tender and that they might have been compliant in regard to other tenders.
They have complied to engine contract, not the component tender contract. Yes.
Which one was
So
that?
this-
Was that
this-
the one from 2008?
No, the one from 2008, remember, is between SAT and Air France.
So
Lufthansa was the supplier of SAT before that.
Before 2008?
Before 2008.
Sorry,
And
so
also,
that obligation that you understood they had been non-compliant in respect of?
that would have been, but like remember also, Chair, I said this tender was ran from 2013 and it was only finalized in 2016. 2016, that's when the supply development was introduced. So by previous, although they are not specific, they might be referring to one of those tenders where they did not commit. But I do know at the back of my mind, Lufthansa has always been that supplier that is reluctant to attenuate to NIP obligation. And that applies to the one previously, because remember, NIP obligation started in 1997. So a person cannot say, okay, because it was a long time ago, therefore it's okay. Yeah. But like, I'm glad that Ms. Hofmeyer understands now that this agreement sent by Mr. October is for engine. It's not for component.
So in 2013, it was compliant with its NIP obligations, correct?
For engine.
No, but it wasn't a supplier for components at that time. So in 2013, Lufthansa was I understood you to say the components related to the pre-2008 position.
Sorted out. I'm sorry, I'm thinking it will be sorted out. Maybe let's wait a bit. Yeah.
Thank you, Chair. It's not only she who is being confused. I'm also being confused. And it is the manner in which the evidence is being handled. She is given an omnibus set of questions to which to respond to, broken down so that I can also understand as a legal representative. Which tender was Lufthansa involved in? Was it a components tender or was it an engine tender?
Yes, that's why I was saying if you wait a bit, it's going to be sorted out.
I was going to ask Chairperson you to intervene because you have a way of taking those steps.
Yeah.
If you can assist us the way you've been doing. Otherwise, I am also very confused.
Yes, no, that's fine. Ms. Hofmeyer.
Ms. Vermeulen, am I correct to understand your evidence to be that prior to 2008, Lufthansa was a supplier of component services to SART?
Yes.
And it's in respect of those services that it may not have been compliant with its NIP obligation.
And it could also be possible, Chair, that like within these tenders from 2013, when they were responding, like they did not commit to NIP obligation. Because also not committing, like that is counted as well. It does not matter whether the tender is awarded or not. Once the supplier shows reluctance, like that by the CFST, it is looked at. Yeah.
Okay, so then that has been helpful. So from 2013, your evidence is it may have been that when they submitted previous bids for tenders, they didn't comply with the NIP obligation. Is that right?
Why are we talking about 2013 now?
Because you just spoke about 2013.
No, this 2013 was referring to this engine.
Yes, you did talk about 2013.
Just in your answer a moment ago.
No, but like I was explaining, Chair, that remember the tenders that kept on being retracted started from 2013 and finalized in 2016.
Yes.
So it might, I said, it might happen between 2013 and 2016 on those tenders that kept on going out.
That's what she's talking about.
Yes, but now she's referring to 2013 alone.
Well, not really. I don't think she refers to it alone, but she's following up on your evidence that it is possible that even from 2013 onwards, Lufthansa might not have been compliant or might still have been reluctant.
For components.
Yes,
not
for
engines.
Yes. I think that's where she is.
Precisely where I was. Thank you, Chair. I'm indebted. So when this risk in relation to Lufthansa was identified for the final components tender, what was taken into account was that on previous bid submissions they had made on components since 2013, they may not have committed to a NIP obligation. It's
not written there, Ms.
Yes, I'm getting the benefit of your insight.
Yeah, I'm saying, remember I said it is possible, but what the CFST has written is not saying from it, they're just saying previous. So nobody is aware which one. That's why you hear me, they may have been referring to the one before Air France, or maybe between the ones that were cancelled or whatever.
Yes, okay, no, that's fine. So you are saying you are not sure which ones they may have been referring to.
Yeah, because it's not clear with the date, yes,
but
Chair.
you are saying that you do know that in the past,
they did not
they
comply.
had been reluctance on their part to commit themselves to NIP obligations.
Yes, in terms of the components.
In terms of the components.
Yes, Chair.
In regard to other contracts, you don't know.
Well, yeah, with regard to other engine contracts, because they
Yeah.
had lots of contracts with
yeah.
SAT.
Okay, all right.
Yes.
And then we can move to the board decision itself on the final award, Ms. Mamela.
Okay, can we go there? before
The
you
board
ask that?
decision took place on the 9th of May 2016. You'll recall that?
Yes, can we go there?
Yes, of course.
Yeah.
I'm just wanting to establish where we are in the evidence and your knowledge of it.
Okay.
So you recall that the decision was on the 9th of May 2016, is that correct?
Chair, the reason why I'm asking if we can go there, I want to confirm something I'm looking at.
Okay.
So that I don't
Let's
say
go to
I
it.
think so
Yes,
or
let's
I
go
don't
there.
exactly.
Yeah.
It's at DD22F. I think it's the one that was in front of you. DD22F, and you'll find it at page 2304.
Page?
2304.
Page 2304.
Chair, this is the page that you don't like because there's handwriting over the pagination. But we did look at it before in Mr. Human's evidence.
Yes.
If you look for 2305, it's easier. What is this document, Ms. Mamela?
Oh, I'm still getting
Sorry.
there. 2304, right?
Yes.
Okay.
But I think ultimately she wants you to go to 2305.
Indeed. And while you're getting there, maybe I just read into the record what we're looking at. We're looking at the minutes of the special meeting of the South African Airways Technical SOC Limited Board of Directors held on Monday, 9 May 2016 at 8:30 at the main boardroom. And I indeed wanted to direct you to 2305 because that, as I have it at clause 4.1 on that page, or paragraph 4.1, is where the submission relating to the final tender is reflected. And then a little bit further down that we have the resolution of the board in relation to the final tender. Do you have that, Ms. Mamela?
2305.
2305, there's a paragraph 4
Okay.
that says matters for consideration or approval. And at 4.1, it records in these minutes, the submission was tabled and considered. According to the submission, management recommended that the tender be awarded to Air France. A discussion on the matter ensued and the board made the following comments, : A. Management's rationale for recommending that Air France be awarded the tender was not substantive, considering the bidder's resistance to align itself to SART's development agenda, i.e. supplier development. Furthermore, the benefits as outlined by the submission as a result of selecting Air France were not compelling enough to position the latter as the preferred bidder. The concerns regarding JMAAR, especially management view that this bidder was lowballing, could be mitigated by reducing each party's obligations as well as terms and conditions to writing. And then the resolution is reflected. Resolved that the request for the approval of the award of a tender for the aircraft component support and services on ATA chapter for both the Boeing and Airbus fleets for a period of 5 years to JMAAR be and is hereby approved, subject to the mitigation of all risks highlighted in the submission. Do you see that?
I see that, Chair.
Were you aware of this resolution at the time it was made?
Or soon after it was made. Or yeah, you might not have been aware at the time it was made because you were not at the board meeting.
Exactly, yes.
Yeah.
No, apologies. Maybe later that day
Yeah,
or shortly
yeah.
thereafter. Were you aware of the resolution?
We were made aware, Chair, after Mr. Malula Peter, I think he sent the board resolution, but already, as I said earlier, there were already talks that some people already knew what was happening, and some had already notified Air France. Air France was already taking steps to take SAT to court, and all that. But I do know that, of course, we usually get, now when I'm talking about formal, professional formal, yeah, we get the feedback after the CEO comes back from the board meeting.
Okay.
And you were not present at that meeting, that's clear from the minutes, correct?
Correct.
And did you support the decision that the board had taken on that day?
Did I support it?
What
So you
she's
have a
talking
way-
about, what she's talking about is when you came to know that this was the decision that was taken, what was your view about it, if you had any?
Okay, Chair. First of all, when the board, what we're used to, not that it's a legislation or any rule, so that we don't come back discussing written rule or not. The precedents so far, like what we have seen with regard to the board resolution, when they are not happy, like they were not happy with Lufthansa. Remember?
Is that when you say they now, you mean the
The
bidders? The board.
The board.
Well, when they are not happy with a bidder.
With a recommendation.
A recommendation.
Yes, from
yeah.
CFST and management. They usually comment and ask for rework and state what needs to be corrected. Like, for instance, they have said here that the risks that are raised, or whatever, should be this
I'm going
and that.
to interrupt you,
But
Ms. Memela. I want us to go back to the crisp answers.
oh, okay.
What was your view of this resolution? Did you have a view? Did you think it was a good decision? Did you think it was not a good decision, or you had no view at all about it?
Of course, we were all shocked. We were not used to the board making a decision there and there on the recommendation. Now I'm worried that I won't be crisp. But like the board usually says if they are not
Sends
happy,
it back to
go back for a work, and
work,
then
yeah.
when you come back, and then they'll say maybe approval subject to.
yes, yeah.
Or something, or maybe decline, go back for the work and address these issues and come back to us. Yes.
When you say you were all shocked, can I take that to mean you didn't support the decision, or are you saying I was shocked, not necessarily that I didn't support it or I didn't have a view on it, but I didn't expect it?
Okay, I would say, when we say we were, because some of us executives were discussing this, and we said we have never dealt with an issue like this, but at the end of the day, we understood the board being the accounting authority, and they had their own reasons that they made that decision.
Okay.
Thank you. I'd then like to take you to the minutes of the board meeting that occurred on the 15th of June 2016. So it's about a month or so later. For that, Ms. Mamela, you'll have to go into DD 25B. That's your bundle. It's the smaller second bundle. And you'll pick it up at page 621. While you're looking for it, Ms. Mamela, I do apologize. Let me give you the page. It's DD 25B at page 621. Ms. Mamela, I've made an error in what I put to you earlier, and I do need to correct it for the record. I apologize. I've been alerted to it. I said in one of my questions to you, you weren't present at the board meeting on the 9th of May 2016, and that seems to be incorrect based on the minutes. You'll see where we were previously in DD 22G at page 2304. Sorry, F. We were in DD 22F. The minutes of that meeting, the one where the decision was taken to award it to AAR, indicates that in attendance included you. Can you assist us on that?
15th of June 2016.
No, sorry, Ms. Mamela, I didn't want to disrupt things too much. We're going to move to the 15th of June meeting in a moment, so please keep that open.
Oh, okay.
I said that it's been pointed out to me that I made an error in a question I asked you previously. I said that I had thought the minutes reflected that you weren't in attendance at the board meeting on the 9th of May. But it's been brought to my attention that the minutes reflect that you were in attendance. So I'd like us just to clear that up in your evidence. The previous minutes, Chair, don't suggest you need to go there. Just for the record, it's DD 22F at page 2304. You'll see that's the minutes of the meeting of the 9th of May. And in attendance includes yourself. Is that correct? Certainly. The page is 2304.
Yeah, the attendance, Chair, it's written that I was in attendance.
Do you recall that?
No, I don't recall because, as I said, I remember that we got it through the calls. It's just that this one, compared to the one for the GPUs, you see that one, it shows that a person walked in for a specific item, to talk about a specific item. So I may have been given, what do you call this, a pack to attend for a specific item, because I can see that there were also tires. The approval for tires as well. And then also, it looks like I was going to talk about, confirm something from BAC point of view. Yes. So it might happen that I was called for that specific item. It's just that this one is not specific as the GPU's one, because the GPU one, in fact, it depends which company secretary writes, but others say person walked in during this moment.
Yes, thank you for that. So you don't have a recollection of being in attendance?
I don't have a recollection.
Thank you.
Yeah.
I just wanted to clear that up. We can now go to the...
But I'm sorry, you don't have a recollection, but it's possible that the minutes are right.
I'm saying, Chair, it might be possible that because of how it differs from one company secretary to the other.
Yes.
Others are specific that a person is walking in, joining the meeting for a specific item.
Oh, okay.
You know, because I remember I said I don't attend the meeting, but only through an invite when the board requires a certain feedback from me.
Can I take the minutes then? Can I take it that what you are saying in regard to these minutes is that to the extent that the minutes reflect that you were present, you don't dispute having been present?
Yeah,
but what you suspect is that it's unlikely you were present throughout the meeting.
Yeah, not throughout the meeting.
Yeah, you would have been present, you think, for a certain period of time.
Yes.
And the minutes
For a
just
specific
happen
item.
not to show, not to make a distinction between people who were present for the entire meeting and those who may have come and attended for only a short time.
Yes.
Okay.
Thank you. Then I would like to go to DD 25B, because we were going to look there at the minutes of the meeting of the 15th of June 2016. And that was at page 621. Do you have that, Ms. Mamela?
Page 621, yes.
Yes. Now, these are the minutes that we've looked at previously related to the GPUs.
Okay.
And as I have your evidence, you, as you've just indicated, you joined the meeting at a point, and you can actually find that at page 625. If you go to page 625 at paragraph 4.6 there, under the heading Logistics Phased Approach Rollout, it's reflected there in italics, SART HOD Supply Chain Management joined the meeting.
Yeah.
Is that what you were referring to?
Yes, that's what I was referring to,
Thank
Chair. But also I was saying, depending on which company secretary is sitting there, my understanding is that I think for the board at that time it was Mr. Maso, and then for GPUs it was Ms. Makake. So each company secretary write the minutes their own style. Yes.
Indeed. No, I don't think that's a matter of contention. What I'd like to look at is what you said after you joined that meeting about the AAR award of the components tender, because that was also something that was actually discussed at this meeting. And you'll find that at page 627. At page 627, there is a paragraph 4.9, which is headed Addressing the Sunday Times article on AAR. Do you see that?
I see that.
So what this minute reflects is that the Deputy Company Secretary circulated 2 documents from the SAA Board Chairperson, a letter addressed to the SART Board Chairperson and an additional draft letter addressed to the Minister of Finance regarding the AAR article.
Yes.
Do you recall that article?
I don't recall it detail by detail.
Right.
Yeah, but I do recall there were something written on this matter.
Right. It goes on and it says the chairperson gave feedback to the letters and indicated that the SAA board had initiated an investigation into procurement processes and contracts management at SAA and its subsidiaries. She stated that AAR was initially not within the scope of the investigation which was conducted by Ernst & Young because it was not yet conducting business with SART. She continued that the chairperson of the SAA board had then indicated that she would not accept the SART report without investigation into AAR. Thereafter, Ernst & Young had initiated an investigation into AAR. The meeting was informed that the SAA board chairperson was of the view that the AAR contract should be terminated. And then we go over the page to page 628. Members of the board discussed the matter and concluded that on presentation of the tender evaluation to the board, SART management could not support their recommendation to appoint Air France, and therefore the contract was awarded to AAR, which was second best. Do you see that? And then it's recorded here that you reported something to the board, because it says the HOD SCM, that's a reference to you as I understand it, is that correct?
That's correct.
You reported that SART management supported the board's decision to appoint AAR because it was justifiable. And you went on and stated that SART had responded to a letter received from Lufthansa and Air France and had not received any further correspondence thereafter. And you highlighted that the MRO would be more at risk of facing litigation should it endeavour to cancel the AAR award. And then it concludes with the board observed that it was clear that the complaints against the award of the contract to AAR were that of a disgruntled service provider as opposed to legitimate concerns. Do you see that?
I see that.
Would it be fair to say then that by the 15th of June of 2016, you were in support of the board's decision to award this to AAR?
Chair, I think I actually, even before I answer this, remember saying to Ms. Hofmeyer during our meeting on the 6th of December last year, that as much as the board had made their own decision, that was different from management. And yeah, but when the company faces issues like the media reporting negatively on the company and Air France taking the company to court, our duty as SART executives is to ensure that we act in the best interest of SART. That's when I even said we then had appointed the lawyers to represent SART and made sure that SART does not lose. And indeed, the SART won the case from court with cost. So supporting from that period, of course, there was absolutely nothing that I could have done.
Well, I'm not sure I understand the connection that I think you make between the stance of sending lawyers to court to defend SAD because of the obligation to act in the best interests of SAD, because that obligation is always there, whatever you do, isn't it?
Thank you. So I was just confirming that, Chair, that we always have to support the company. And the decision that was made by the board at that time, it had already been made. And we had to go with it and make sure that we defend in court.
Yes.
Yes.
But your obligation to act in the best interests of the company doesn't mean supporting a wrong decision, isn't it? Or does it go that far? I'm just wanting to clarify this particular part of your evidence.
Chair, remember when I responded, I said the board made their own decision.
Yes.
And they had their reasons why.
Yes, yes.
Which is, my understanding is that I know that maybe one time or eventually you will call the board members in to respond on their behalf, or on their own. So they will be able to give reasons why they took that decision.
See,
So I said for us, because we were talking between management and we were shocked at that time.
Yes.
And I explained why we were shocked. It's because usually the
Yes.
board, when they are not happy.
Okay, don't explain again.
Oh, okay.
I would understand if you say, look, we might not have agreed with the decision, but the board had made the decision, and some of the decisions that are made by the board, we as management just have to live with. And that I would understand.
Oh, I thought I was making that point.
I didn't understand acting in the best interests of the organization in that connection.
Yeah, okay. No, I meant it that way.
Okay, all
Yeah.
right.
So when it was recorded in the minutes that you reported that SART management supported the board's decision to appoint AAR because it was justifiable.
Yes.
See, when I read that, it suggests to me that you'd evaluated the reasons given by the board and you regarded them as justifiable. Is that not the correct reading?
Okay, Chair. Of course, like it will be based on the interpretation of what the reasons of the board were at the time. And of course, the board had said the risks that we had raised, that because there was low bowling in some part of the space, and then also, I don't remember what other risks were, or in terms of the fact that AR did not have a footprint in Africa, therefore, but like there were lists that were listed by CFST and management. Yeah, so when the management sat and discussed, we understand that, okay, I think we thought this could have been something that was going to be managed. Yes.
But I thought that you were saying earlier on that you were all shocked at the decision taken by the management, by the board,
yes.
I'm sorry. And my understanding is that the decision you were talking about was the decision that AAR be appointed. Was I correct in understanding your evidence like that? That the decision that shocked you was the board's decision to appoint AAR. Was I correct understanding that?
That was the board decision to award or make a decision to award that and that, because usually they send it back. I even said there's no legislation against this or the rule. But like, I mean, we were used to the
there
board.
Was a practice.
Yes, we were used to the board when they're not happy about a certain submission, about a recommendation. They will send it back for a work, or maybe say approved, subject to, or yes, or decline.
Did you mean that you were not shocked by the fact that the board said the tender should go to AAR? What you were shocked about, what shocked you, was that the board did not say we are happy that the tender should go to AAR, but we are sending it back to management to do the formalities.
Okay, Chair. I'm going to repeat. I said we were shocked
By what?
that the board had made an immediate decision to award.
Yeah.
Remember, the recommendation is made by the CFST and then through management until it gets to the board.
Yes, yes.
And when the CFST makes that what the recommendation, it's based on their evaluation,
Yeah.
and satisfied and
Yes.
yes. So when the board made that decision, we were shocked with that. It was we were not used to.
Were you shocked by the fact that the board made a decision that went against management's recommendation? Is that what shocked you?
Yes, we were shocked about that, Chair, the fact that it was against the CFST recommendation and management.
But how would you be one of those who were shocked if at the meeting you said SAT management supported that decision?
No, this was not the same meeting, Chair.
Oh, it is not the same meeting?
No, it's not the same meeting.
Okay.
The meeting
Okay.
for the board was on the 6th or 9th
No,
of May,
that's
and then
fine.
that one was on the 15th.
I must have misunderstood
Yes.
you. Okay,
So
thank you.
that followed after the board decision.
Takes
So
the
it was
decision.
not
Okay,
something that was
okay.
said in the same.
So by the 15th of June, had you satisfied yourself about the justifiability of their reasons?
Had I satisfied?
Well, the answer can only be yes, I had, or no, I had not.
Okay, no, I had not, Chair.
Yes, that's crisp.
Thank you. So did the minutes not correctly record then what you reported to the meeting?
Okay, Chair, when you support does not necessarily mean you agree
I
100%. Exactly. When management says we support the board decision, because there's nothing we can change. They took that decision. They are the senior power, and even if maybe we had shown our dissatisfaction or maybe our disapproval, maybe I will be sitting here being charged for insubordination. I don't know, but I'm just saying supporting does not necessarily mean you agree with how the decision has been taken. It means like you respect authority sometimes.
Well,
but like, at the same time, Chair, I'm not saying I had at that time when we were saying we supported, satisfied myself.
Evaluated.
Yes.
Yeah, you had not evaluated.
Yes, Chair.
But you are saying that when in this meeting you said the site management supported the board's decision, you are saying that that didn't mean, you are not meaning that the site management agreed with the decision.
Yes, Chair, because I think even if I had said I disagree, there was absolutely nothing that I was going to do.
Well, you see, I don't understand your evidence when you say, if you say you support, you don't mean you agree. I thought if you support something, it means you agree with it. I would understand if you said management, the site management will implement the board's decision, because implementing doesn't necessarily mean you agree with it. It might just mean you accept that there's nothing you can do. Your job is now to implement, now that the decision has been made. But if you say you support, that suggests to me that you are happy with the decision.
No, but the decision, Chair, was made on the 9th of May, and this meeting was on the 15th of June.
But if it could have been made the year before, but if you didn't agree with it, you would still not want to say you support it.
The only way that I could have shown my maybe disagreement would be if the board would have sent it back to CFST, and then we'll have stood our ground maybe and say, okay, we still are recommending a France based on these grounds. Then should the board decide otherwise, then it's up to the board. So they took the decision there and there.
Yeah,
Yes.
Ms. Hofmeyer.
Thank you. Let's move then to your role in the contract negotiations, Ms. Mamela, if we may.
Okay.
I understand you to have been involved in those contract negotiations. Is that correct?
Chair, involvement versus attending the first contract negotiation where all parties, like between SAT and ARJM sit. Yeah.
So you would say limited involvement?
Limited involvement, Chair,
Okay.
yes. Because after that, then the negotiation was not I was not involved in negotiation.
Amongst the team who were negotiating were Ms. Mbeki and Mr. Kenny, is that correct?
Yes, Ms. Mbeki from the legal framework point of view, and Mr. Kenny was there to guide in terms of, just that I don't remember who exactly were there, but was there to guide in terms of the technical side of things, yes.
Ms. Mbeki has provided an affidavit to the Commission, and it's been included in your bundle. Let me take you to it. It's in DD 25B, and it commences at page 464.
Yes.
So this is an affidavit of Ms. Mbeki, who indicates in it that she was involved in the negotiations. But I'd like to pick it up at paragraph 12 of her affidavit, which is at page 467. At paragraph 12 there, page 467, Ms. Mbeki indicates the following, and I'll read it into the record. Given the complexity and technical nature of the component support services, Advocate Mamela established a team of people to take part in the review and negotiation of the said agreement. And then she goes on and she says the said team consisted of the following officials, and then there's a list of a number of officials. And she concludes that paragraph to say the SART team was under the leadership of Advocate Mamela, with the assistance of Mike Kenny in their capacities as SART executive and executive committee members. Do you have any reason to dispute what Ms. Mbeki says there about the fact that you were leading this SART team?
Leading the SAT team throughout the negotiation? Or what?
Yes, she said you established the team,
Yeah.
and then you led the team.
I suspect that maybe she may have not put the date, but I know that, as she states here, this is the team chair that was on that first day that I'm talking about, because like we had noticed that people who were coming from AR were, they had senior people like vice presidents and all that. So we attended on this one. So it was not throughout the negotiation.
Did you remain the leader of the team throughout, even if you did not attend every meeting?
The leader, how, Chair? Where I negotiate.
Here she says the SAT team was under the leadership of Advocate Mamela. Is that part correct?
Yes, and my understanding, she's talking about that first day.
A particular meeting?
Yes, that first day, yes.
But she says you established a team, and she gives the names of people there. Is that correct?
Yes, like I mean people who will be representing certain section.
Over a certain period of the negotiations, isn't it?
Over a certain period, but for me, I only participated on that first day.
But would those people not be reporting to you over that period?
No, they will not be reporting to me because they will be, for instance, Wellington Newswa.
Who would they be reporting to about progress in the negotiations?
Progress, like how far is the negotiation now?
To say we have a meeting, these people are being difficult now, or this or that, or anything like that.
There has never been that kind of progress reporting, Chair, that okay, they report to Nonsasa now that okay, this is where we are. and stuff. Like, my understanding is that once, like, I mean, the contract is being negotiated, people are independent to play their role as management. Because all these people that we see here, they were part of management, except Evelyn was a specialist and Stan Foslow.
Okay, Ms. Hofmeyer.
Ms. Mbeki says that you were not only in attendance at the first meeting, she says you were in attendance at the second set of meetings as well. We can find that at page 470. And at paragraph 18, she says, I do not remember the exact date of the second set of meetings, but it also took place in June 2016. It took place over 2 days. I do not remember receiving a meeting invitation for this meeting, and it does not appear in my diary, but I confirm that I did attend the meeting. I was called to the meeting by Evelyn Fallett. Evelyn Fallett, is that a SART representative or an AAR representative?
Is a SAT representative. She's actually a specialist.
And she goes on and says, I was called to the meeting by Evelyn Fallett, who said that Advocate Mamela had sent her to call me. It is at this meeting that the draft component support agreement was presented to the SART team by the JMAAR team. If I remember well, the following team members were present on the first day of that meeting. So that's the second set of meetings over 2 days that took place in June. Does this help jog your memory?
Chair, I feel that
Maybe we can take note of the fact that she starts that sentence by saying, if I remember well.
no, Chair. I feel that if I should have received Rule 3.3 on this.
It's been in your bundle since last week.
The Rule 3.3. I'm not talking about the bundle. I'm talking about the Rule 3.3 where I'm supposed to respond to when somebody is talking about me. And
no, you get a 3.3, Ms. Mamela, when there's a witness whose evidence is going to be presented who implicates you. This is the evidence of a witness who's talking about, not who's giving oral evidence, whose affidavit is admitted provisionally, and who's just talking about who attended meetings.
No, but Chair, here the affidavit says I was the leader of the negotiation and I have led the negotiation throughout. I'm not sure about that.
Okay, well, you see, there have been...
because I'm not sure even...
Hang on, Ms. Mamela. There have been issues where people have said the commission is bothering them by sending them Rule 3.3 notices when they are not implicated by witnesses. But the commission has said, you know, sometimes it's clear that somebody is just being mentioned and is not being implicated in anything, but sometimes difficult to say, and therefore to be on the safe side, sometimes they send. But it's true to say, you know, the legal team needs to take a view whether somebody's name being mentioned is sufficient to be implicated. But I thought Ms. Hofmeyer was making the point that the bundle was made available to Ms. Mamela some time back.
Yes, so Ms. Mamela received the full set of her bundles when she appeared for her evidence on Friday.
Yeah.
So this has been in there since then. The second point is that, as you've indicated, Chair, all that happens in Ms. Mbeki's affidavit at this point is she's talking about who was attending meetings at what point. That, on its face, certainly the view of the legal team was that that did not implicate Ms. Mamela.
Yes,
It is arising from her evidence that there seems to be a dispute between her and Ms. Mbeki, but that is only something that we learn in the course of the evidence. Because it is as possible that when I put to Ms. Mamela, did you lead it? She might have said yes. She might have confirmed having been at more than one meeting. But it's in the course of the evidence that she says it was only at one meeting, and then I draw her attention to the different version that Ms. Mbeki has.
Yes.
There's no reason why Ms. Mamela can't tell us she disagrees or the basis for why she disagrees.
Yes.
So I submit that we continue to look at Ms. Mbeki's affidavit.
Yes. Ms. Mbaldra?
Thank you, Chair. I just want to point out, I see that every time there is a complaint from the witness, Ms. Hofmeyer raises the point, correctly from her perspective, to say, you have had these bundles since Friday. But let us be realistic. There is no human person who can be able to go through each and every item of these bundles if these bundles were given to a person or on Friday. And I'm not wasting time, Chair. I'm just putting it on record. Even myself, ever since I came in back from Cape Town, I started consulting first on the videos, and I only had 3 hours sleep. Yesterday, I had 2 hours sleep because we are receiving.
Well, I had only 4.
Yes, Chairperson. No, maybe you even sleep less, to be honest. But, but all I'm trying to say, I'm saying, irrespective of how little we see, these documents remain voluminous. So it is a bit, maybe, I understand from the position she comes from, because she is not in our position. For instance, and I just want to also put it on record here, if you look at the manner in which the evidence is being presented, on the first day it will be on GPSU, it is left. Again, on the second day, it goes back to the GPSU. Even for me to concretize the evidence, because it is being presented in such a jumbled manner, is going to be a problem. And I'm raising these issues now so that when we complain later, we have placed them on record. Thank you.
Yes.
Chair, Ms. Mamela, until Friday morning, was not, her public indication was that she wasn't going to be appearing on the morning of Friday. That is the background to why the bundle is given to her on Friday morning. And it's since that point that there has been available access to it. I fully understand Ms. Mbanjwa's point that the documents are voluminous. They are. We've had to get on top of them similarly and deal with things at quite a rate as additional statements. For example, Ms. Mamela's cross-examination applications responses came in the course of last week. I don't intend to belabor the point. There are 1 or 2 aspects of Ms. Mbeki's affidavit that I'd like to put to Ms. Mamela. She believes she's not in a position to answer them. She can give that answer, but it's really 1 or 2 further matters if you give me leave to do so.
Okay, no, that's fine.
Thank you.
You understand that, Ms. Mamela?
Yes, I will take
If you are not able to answer, you don't remember, or you need time to refresh your memory, you know.
Chair, I will take the question, but I feel that, remember, I was affirmed that this was the fact-finding mission. But as we continue, and with all these new affidavits coming to me, and before getting the Rule 3.3 that you are mentioned, that you're being a leader of the negotiation, I feel everything about this AR JM is being pointed at me. Because like I'm being asked about like my support for the board, what did I think and stuff, and then while I'm still focusing on that, how do I, and then there is here that I'm leading the negotiation. So that's why I was confused that leading the negotiation, does it mean I'm the one who's running with the negotiation, discussing it with the other lawyer from the other side, or was Ms. Mbeki the one who was drafting and negotiating the agreement? Because that was my understanding, that when Kuki was brought in SAD.
Well, maybe let me say something to you about the question of whether you were leading the negotiations or the team. That's what I understand Ms. Mbeki's affidavit to say. But if you are asked the question, were you the leader of the team, you give an answer based on your own concept of understanding of the concept of being a leader. If you say, as far as I'm concerned, I was not the leader of the team, because if you look at the number of meetings that were attended, I attended less than 20% of the meetings. and the people were not reporting to me. So you give your own understanding to say, I don't know what she has in mind, namely Ms. Mbeki, but as far as I'm concerned, I was not the leader. This was the position.
Yeah, because until now, Chair, I'm learning that it's as if maybe Ms. Mbeki was not independent enough to negotiate or draft or review the contract on her own.
Well, if as far as you know, she was the leader of the team, then you should say, as far as I know, she was the leader. If it was somebody else, you say so.
She was leading the negotiation from the legal point of view.
Yes.
As like she was taking care of the legal framework. And I remember during, as I said, that I was there in the first meeting. And my understanding was that the reason why it was put like it was for her and the lawyer from AR to work on the template of the contract that was going to be worked on going forward. And then once that is cleared out, with Mike and other people there that will be talking about the technical or commercial part of the contract, then she will continue independently with the legal team of ARJM. Yeah, so now it's as if now it's.
But all I'm saying
I don't know.
is,
maybe I'm interpreting it wrong.
All I'm saying is that just because somebody is saying something about you that is not true, that doesn't mean it should be a problem. You can say that that's not true, at least on my understanding, that's not the position. This is the position as far as I'm concerned. Okay, all right, let's move on.
Thank you. Ms. Mbeki refers to the second day of that second set of meetings at page 473. And she indicates at paragraph 25 there that during the contract negotiation process, this is paragraph 25, there were a lot of instances where there were...
Is that 25 of her affidavit?
Indeed, Chair, at page 473.
Okay.
She says there were a lot of instances where there were disagreements between the SART team and the JMAAR team on some issues. Some of the disagreements were so bad that I was accused by the JMAAR team of deliberately delaying the conclusion of the contract and frustrating the process. They told me that I keep on raising issues and/or concerns which are already discussed and agreed to with the SART team. I was even reported to my superiors for allegedly frustrating the process and causing a discord among the negotiating team. I do not know who, when, how, or to whom I was reported. I only came to the realization that I was reported when Ms. Shabalala informed me that Advocate Mamela said she must tell me to call her urgently. This happened on the second day, and as I stated in paragraph 20, Advocate Mamela did not attend the meeting that day. Upon receiving the message from Ms. Shabalala, I called Advocate Mamela. During the telephone discussion, Advocate Mamela told me that she'd received a complaint that I keep on raising issues which were already discussed before I joined the team the previous day, and that as a result of my conduct, the discussions were taking longer than necessary. She also told me that this concern was also raised with the then Chief Executive Officer of SART, who was also the acting Group Chief Executive, Mr. Musa Zwane. I admitted that I indeed had been alerted by the team that a lot of the issues I was raising were already raised, discussed, and resolved the previous day. Do you recall that conversation that Ms. Mbeki said you and she had?
I don't remember, Chair.
And she goes on and talks about the remainder of the negotiations and her role in them. She particularly emphasizes the points in the contract that she was fighting for being retained. And then she tells us what happened in the final sign-off of the agreement. There are just two aspects I'd like to draw your attention to there. And for that purpose, you'll have to go back to page 472 at paragraph 23.
472.
Apologies, Chair. I see Ms. Mbanjwa would like to make a comment.
Ms. Mbanjwa.
Thank you, Chair. It's not an objection, but I just want, my apologies, Chair, I'm still far. This is not an objection, but because The idea is a fact-finding of this commission. I'm just drawing the attention of Ms. Hofmeyer to the fact that she has read from this paragraph selectively. And with your permission, Chair, I just want to point out that she must read the paragraph to the end, because what has been left out is also very, very important. And if I can just include it quickly.
Hang on. That's an issue that's quite appropriate for re-examination, where you say she might not be an opponent in a commission setup, but you point it out in re-examination and you direct the attention of the witness to the whole part that should have been read.
Thank you, Chair. I don't want to be
Yes.
long on this. I just want Chair to take it into account in conducting these proceedings. I am trying to avoid objections.
Yes.
Because it wastes time. Now, I'm saying to my colleague, because if my colleague is going to read the documents, take the prejudicial part, and leave out the favorable part, it means, therefore, that when I re-examine, I'm going to technically re-examine on every document that she has presented to this commission. Whereas it would be very easy if, for instance, she could have included what the admission is, because if one looks at that paragraph, it says that Ms. Memela complained about the fact that Ms. Mbeki was causing frustration because she was revisiting things that had already been done. But there's a very important caveat to that. It says, I admitted that indeed I have been alerted by the team that a lot of the issues I was raising were already raised, discussed, and resolved the previous day.
Yes.
Therefore, there would be no need for me to re-examine, because the paragraph itself contains the concession.
No, I understand what you say, but let's try make a note and raise it in re-examination issues like that, because the more we have an interruption to talk about them, the more the delay. Whereas if she ends up not covering it, I will allow you to cover that, to say there is a part where she read only a certain part and left out a certain part that's important for the witness's evidence. So let's try and make a note, and I will allow you.
Chair, I'm not being like, this is the last statement I'm making.
Yes.
I am saying, Chair, if the documents presented to the Commission by Ms. Hofmeyer were read in their fullness, including where the fullness will reveal the fact that the documents are not blaming Ms. Memela, that would save time, because then I would not have to re-examine on those documents. Like, for instance, this is a very crisp example. Here is a document where an accusation is being made against Ms. Memela, but that accusation has already in it a concession. Then Ms. Hofmeyer deliberately doesn't read the concession, so that she takes only the accusation, which therefore means I'm going to waste time, because then I must.
You see, she might, for the question that she was posing, she will talk for herself. She might not have seen that part as particularly important, but you, representing the witness, might see its importance. So that's why I'm saying it might not have been deliberate, but it's fine, she will talk for herself. But I'm emphasizing that make a note, you get a chance when you re-examine to say, let's go to that page. Ms. Hofmeyer read only up to this point to you before you answered. Here is another point. And then the witness can then deal with that.
Thank you for your patience.
Okay.
Chair,
Ms. Hofmeyer.
the transcript will bear out that I read that last sentence of the paragraph.
Yes.
I was absolutely scrupulous
Yes.
to ensure that I read the entire paragraph 25.
Yes.
And I included the last sentence
Yes.
that Ms. Mbanjwa has just said publicly, I deliberately omitted. I read it out, and the transcript, when we get it tomorrow, will reflect that.
Yes. Thank you.
Let us then move to what she says about the aspects that she emphasized in the course of the negotiations. One of the things that Ms. Mbeki was...
Maybe, Ms. Hofmeyer, I see we are at 3:30.
Yes.
If we are not going to adjourn at 4, it may well be that we should talk
Indeed.
now, or if we are going to adjourn or not. I know that it's been difficult to keep to the time frames that we were all hoping to keep. How far are you from finishing?
I have 2 more pages of notes to cover.
And that should absent questions from me. And assuming Ms. Memela gives crisp answers as
Yes,
she did.
and
at
there
some
aren't
stages
objections or
Yes,
comments.
yeah, how much
I
time
would
would
imagine
that
about 20 minutes.
About 20 minutes. Okay.
And can I just be clear?
Yes.
I'm not suggesting by my answer
Yeah.
that there shouldn't be interruptions. I'm just
Yes.
endeavoring to give a time frame
Yeah. Yes.
on the only basis I can,
Yeah.
which is what
Yeah.
I can control.
No, that's fine. And then once you are done, which it looks like would be around 4 o'clock.
Yes.
Have you and Ms. Mbanjwa talked about what
We have.
could happen after that, subject to my approval?
Indeed, it was always subject to your approval, Chair, but I did confirm with Ms. Mbanjwa if she and Ms. Mamela are in a position to stay later than 4. She did indicate to me that they were. They've travelled together so that they can both remain to beyond 4 o'clock. It would be our suggestion that we do use additional time. My grave concern is that we haven't even commenced Mr. Nzeku's evidence today. So my proposal would be I complete by 4. Then we move to the re-examination that Ms. Mbanjwa would like to conduct, and we take that as far as we can. It would also be our suggestion that we try and start a bit earlier tomorrow because it is a short day, so that we can get as far in Mr. Nzeku's evidence as possible. Those are our proposals.
Well, we can go beyond 4, but unlike, was it yesterday? Yeah, unlike yesterday when I could have gone up to 6.
Yes.
I don't think that I could go beyond 5
Right.
today. But the question arises, if we can only go up to 5, how much can we cover?
Well, Ms. Mbanjwa's indication yesterday was that she would probably need about 2 hours for re-examination.
No, she said much more. She wanted the
Oh,
whole day.
apologies, yes, and you
I was the
confined
one- I
her.
was
Sorry,
the-
you're
yeah.
absolutely right.
Yes.
But whatever amount of time you permit, it would be my suggestion that using an hour beyond 4 o'clock to make some serious headway in
Yeah.
the re-examination
Yeah.
would be conducive,
Yeah,
because
no, it would
Mr.
be.
Nzeku does need to start
Yeah,
tomorrow
yeah.
in his evidence.
Yes. How long is Mr. Nzeko likely to take once he has started?
You know, Mr. Nzeku, we don't have a statement or affidavit from.
Yes.
So, and we still haven't got an affidavit that has been promised to us for a week from his co-director in JM Aviation.
Yes.
But I was told by my learned friend at lunchtime it should have been coming through sometime this afternoon. I don't know if it's come through yet. Based on the areas that I propose traversing with Mr. Nzeku, I should imagine half a day would be adequate for his evidence. That's why I'm particularly keen to start tomorrow and hopefully finish.
Well, if Ms. Mbanjwa starts at 4, for example,
Indeed.
or thereabout, and we can go up to 5, that will be an hour. And I agree that whatever we can use should be used. Then if we started I don't know if we could start at 9, but maybe we could start at 9:30. then if it's another hour, that takes us to 10:30, or depending when we started, let's say up to 11. That leaves that leaves us with very little time for Mr. Nzegu before I become unavailable.
Indeed.
So I have my reservations whether we would finish with Mr. Nzegu, even if we started with him. And if we won't finish, if we are unlikely to finish, it may well be that an alternative arrangement should be considered, because he would have to come back anyway.
Yes.
And then attempts would be made to make sure that on the day he comes back, he finishes on that day. But one can never be 100% sure about these things. So that's what's going on in my mind.
Yes.
Rather than start with him tomorrow and not finish.
Understood, Chair. Indeed. The only challenge will be that we have an absolutely full schedule next week. There would be no period within next week to slot him in.
Well, we previously talked on the basis that we would not sit on Friday.
Correct.
There may be a possibility that maybe we could sit from some time about maybe after lunch or thereabouts. But it may be that we might not need to do that if we can find another day. Within Feb, when Mr. Nzegu can then come back.
Chair, why don't I do this? Why don't we proceed with Ms. Mamela?
Yeah.
I can then have engagements with Mr. Nzeku's legal team at the conclusion of today, because whatever happens, Mr. Nzeku's not starting today. And then we can come back to you with a proposal for his evidence.
Okay, let's do that.
So if we can then just continue
that's fine.
to round this off. Ms. Mamela, one of the things that Ms. Mbeki says she was pushing for in the negotiations, and you'll find this at page 472 at paragraph 23, was the inclusion of a penalties clause in favor of SART. Now, we've looked at the contract previously in the evidence, and we had the evidence of Mr. Human about this. That penalties clause was not ultimately incorporated in the contract. Do you know what, it's a penalty clause in favor of SART. There's certainly a penalties clause that if SART does not perform, then JM or AAR have penalties levied against SART, but there's no concomitant penalties clause against JM or AAR. Can you help us with insight as to why that proposal of Ms. Mbeki's was not carried through in the contract?
Proposal to which?
In the course of the negotiations of the contract.
I'm not sure, Chair, because my understanding is that the only time that when she was asked about why was the penalty clause not in the contract, she was asked by Airbus when I was acting the Chief Procurement Officer at SAA, and that she defended and stated like which provision that she had, but she had never to me said, boss, this is what happened, I was raising this point, but it was kicked away or something like that. So I'm not aware of it.
And did you take any steps to ensure in the contract negotiations that there would be a penalty clause in favor of SART?
Me?
Yes.
Okay, Chair. Cookie, Ms. Mbeki, when she negotiates and drafts and review contracts, she does that since like she was appointed specifically for that. She does that independently without me. So me taking a contract from her and checking it, like that has never been a norm, that like, okay, I must check and finalize. Even in her sign-off form, sometimes when she finalizes a contract, she takes it to certain people, not to me to sign it off, because remember now we'll be doing a duplicate work. She's a lawyer, I'm a lawyer, so yes.
So what steps did you take in the contract negotiations to make sure that SART's interests were protected?
Okay, I did not negotiate the contract, Chair. The contract was negotiated by Ms. Kukimbeg for legal framework.
So you didn't play a role in the negotiations?
I did not play a role, except when that first day, Chair, where I said that it was put on the projector, and then the provisions were put down of what should be in the contract, and then like all the people that she listed in her affidavit were sitting there. We looked at the projector. It was not something that me, as her boss, like will be, because I know she was doing that. One thing I don't do, I don't micromanage. All the senior managers that reported to me were doing their job independently, except when they raise something that they need my support. Because my understanding, she was quite strong and like knowledgeable in terms of negotiating. And I showed her my support from the first day when we were sitting there, because I remember like she was supporting the view that maybe, in fact I supported her on that, the view that maybe the JV or maybe the JM aviation should be an annexure to the contract. And the other point that I remember that she made was like to make sure that the lowballing that the CFST had raised in terms of like AR, she had put, or she had forced AR to agree to a certain provision that talks to capping or putting, like, keeping fixed the price until 2018, if I remember correctly. So like those were the provisions that like, she discussed with me and I supported her. So I don't know, maybe Ms. Hofmeyer doesn't understand our structure and stuff, that certain things doesn't really come to me for my finalization, because Ms. Kukimbeg is not a junior lawyer.
No, but she was junior to you in the structure of SART, is that correct?
She was junior to me, but like heading her legal and contracts management unit, so, reporting to me as HOD. Remember, like I actually read the portfolios that I was heading. Yes.
So she reported to you, but at no point prior to this agreement being concluded did you satisfy yourself as to its contents. Is that right?
I'm saying, Chair, I gave her the independence to negotiate, because I know her, when she's not happy about something, she will come to me, in fact, for ask if she needs my support. So that's why I'm saying, like, I'm surprised with the issue of the penalties, that she said she was pushing for penalties and then she was not allowed. But like, she's not saying by who did not allow her. I'm surprised because this was raised by Airbus, and she and the meeting was between myself, her, and Airbus, and she had already moved to SAA at that time. So she never raised this as something that like she was not allowed. She had pushed for it. Instead, she defended that, okay, but even if this is not there, still, there is this provision that are protecting SAT.
So can I just get clear on the evidence? You did not satisfy yourself as to the content of the agreement before it was signed on the 7th of July 2016. Is that correct?
I did not check or maybe finalize the contract because it was not negotiated by me.
And do you know that Ms. Mbeki didn't get to check the contract either before it was signed?
I don't remember that. Yes.
Her evidence at page 475 at paragraph 29 of DD 25B was the following.
The page?
475,
okay.
It's a few pages on in her affidavit, and I pick it up at paragraph 29.
Mm-hmm.
She says, on the 7th of July 2016, my plan was to arrange a meeting with the SART team members to go through the agreement clause by clause as I usually do. I was not aware that the agreement had already been signed until about midday on 7 July 2016, when one of the other SART team members informed me that the agreement had already been signed. I can't remember whether it was Mr. Vosloo or Mr. Kenny who informed me about the signing of the contract. Upon hearing that the agreement is signed, I then stopped reviewing it. I did also not go ahead with the plan of arranging a meeting with the other team members to further deliberate on the agreement, because the said agreement had already been signed. Who arranged for the signing of the agreement, Ms. Mamela?
I wouldn't know. Remember, the signing of agreement share will be arranged by the person who was working on the agreement, naturally. So I'm not sure then.
So it wasn't Ms. Mbeki. Who could it have been?
No, I don't know, because I'm seeing this evidence now. I don't know if she said she was not the one.
You'd have expected her to have been the one.
She should have been the one, because remember, she was the one who was negotiating with the legal person from AR. So I don't understand at what point that...
And it seems strange that if she was the leader from the legal point of view in the negotiations of the contract, it seems strange that while the leader of the legal team, so to speak, who was to advise whether the contract is ready for signing, while she was reviewing, looking at the contract clause by clause, somebody decided it should be signed.
You have no knowledge about
I
that?
have no knowledge about it.
Yeah, okay.
Yeah, she goes on in her affidavit to explain the standard practice that she follows to ensure that there's proper review, and she said she had no opportunity to do that. But I take it that your evidence is you don't know how that signing was arranged. Is that correct?
Yeah, I don't know, Chair.
I'd like to pick up on my final point before concluding aspects.
And that, I'm sorry, and that has to be taken to also mean that you were not at the signing of the, did not attend the signing of the agreement.
I don't remember, Chair. Can we, if the contract is here, can I be...
Oh, you want to
directed to
look at the signature page?
Yes, certainly. Oh, I just put it away. I'm sorry. Where were we? Right. We were in...
The signatures are at 489, 490, 491, is that right? Or am I on a different contract?
There are two contracts, and I just want to be sure that we're not in the wrong one.
Okay.
The one is the Swiss port,
Yeah.
and the other is the
Okay.
components. And I literally just had it in front of me.
Oh,
Let me find a chair. Oh, here we go. All right, sorry, apologies. It is DD22F. And you're not
I'm
reflected
looking
on
at
the
the,
signature page, Ms. Mamela. I'll take you to it. The agreement commences there at 2318.
2318.
2318, and you'll find the signature page at 2333.
Oh, which bundle?
DD 22F.
22F.
Yes.
Yeah, page?
The signature page is 2333. 2333. There's no indication on that page that you were a signatory to the agreement. Do you see that?
Oh, I just wanted to go to the first.
Yes, sure. The first page is 2318.
it's interesting that there were no witness provision, there were no witnesses to the signing of this contract.
Indeed, Chair. The other thing that's noteworthy, I'll take you to some of the clauses. That the clauses are very oddly numbered.
Yes.
If you go, for example, to page 2325, where I'm actually going to pick it up, you've got a heading there for pricing and payment. Sorry, at 2325. You've got clause
Yes.
4 there, pricing and payment, and then the first subclause is 4.23.
Oh,
It's all over this agreement.
yes.
Which does seem to lend some credence to the notion that this was rushed towards the end, because these would have been points, presumably, in that review that Ms. Mbeki would have picked up on.
Yes.
So it's very strangely arranged. Ms. Mamela, I would like to take you next to 2325, because there's a particular clause there that is the last aspect I'd like to deal with you in evidence. Do you have 2325?
I'm so sorry, 2335.
2325. Ms. Mamela, just before we get to this clause, we dealt with Mr. Kenny's affidavit in the evidence of Mr. Human. That was an affidavit where there was an implication in respect of you, and so you received a 3-3 notice. Mr. Kenny indicated that after the contract was concluded, he attended a meeting with you at which he requested to be given a copy of the full contract. And you said to him he could only have the page that was relevant to him, and he makes the allegation that you'd said that was to protect him. Do you have a response to that?
Chair, my understanding of Mr. Kenny's affidavit, it was referring to the collaboration agreement. Yes, that was...
No, it was referring to the components agreement. But do you have a recollection of a meeting with him at which you said that he shouldn't be given a full copy of the agreement?
Maybe let's go to that document.
Certainly.
I think that's what
please,
Ms.
it will
Mbanja and
remind
Ms.
me.
Mamela would like. Let's go to where he says that.
Yes, I just need to find which one it's going to be in. It's in G. It's in 22G. Oh, yes.
22G.
22G, and you pick it up, apologies. Mr. Kenny's affidavit begins at 3150. That's where the affidavit starts, and the relevant paragraph I'm referring to is at page 3155.
Wait.
3155. So we're in DD 22G, and we're at page 3155. This is in Mr. Kenny's affidavit. And at paragraph 23 on that page, I'll just read it into the record. He says, at one of the EXCO meetings after the agreement with AAR JM Aviation had been signed, I asked to be provided with a copy. Ms. Mamela told me that I could not be given a copy of the full contract and would only be given a part of it. I took issue with this and asked why I could not be given the whole contract, and Ms. Mamela said that it was to protect me. I do not understand what that meant at the time, and I still don't understand what she was conveying. I have never seen the full contract. Do you have a response to that?
Chair, I think I might have read, I haven't responded to this affidavit, I think.
No, you haven't provided any statement or anything, but we have the opportunity now just to ask you what your response is.
No, I don't remember this
don't.
discussion with Mr. Kenny.
Did you receive
Was it a verbal discussion, written discussion?
He says he asked to be provided with a
I
copy.
think he says it was at a meeting.
It was?
He says it was at a meeting.
At a meeting.
Of EXCO, if I
Yes.
Yeah. So it
At
would have been
EXCO.
verbal, yeah. He says at one of the EXCO meetings after the agreement with AAR/JM Aviation had been signed.
Chair, I've raised this concern again before, that I feel that, I don't know, I may be wrong, the way people are writing about non-SASA to an extent where even Mr. Human, Skull Human, who has never set eyes on me, has something to say about me. I'm not sure if they're being guided or something, but like I will just like answer the part where it's not even possible that Mr. Kenny, remember, first of all, I don't manage contracts. There's no way that like he will ask me for the signed contract, especially during EXCO meeting that is chaired by Mr. Asin Malola Piri, who was an acting CEO, who signed the contract. You understand? Like, I mean, I'm not sure why he would ask me specifically for the contract instead of asking Mr. Asin Malola Piri, the signatory to the contract.
Well, he may have asked you because he says in another paragraph of his affidavit, paragraph 21, the page before the one where there's paragraph 23, she says, you and Ms. Mbeki were responsible for the legal aspects during these negotiations with Ms. Mbeki taking the lead on the drafting. So
you see,
where you said Ms. Mbeki was, as far as you are concerned, supposed to be the leader of drafting, maybe part of what he says here supports that.
Yes.
But he does say that you and Ms. Mbeki were responsible for the legal aspects during the negotiations. Maybe that's why he was asking you for a copy.
But Chair, Mike knows that I only managed contracts when I was holding Ms. Mbeki's position, legal and contracts manager. So there's no way he will ask me, because from procurement now I was not managing any contracts. Yes.
Okay.
That was the role of Ms. Mbeki, and I'm saying now, since Ms. Mbeki, in fact, Ms. Mbeki was taking part in EXCO when Mr. Zwane had gone and acted at SAA. So I'm saying with Ms. Mbeki there and Mr. Malola Piri there being the signer of the contract, both in attendance in EXCO, and then he specifically asked for the copy of the contract from me. Chair, no, it just does not add up. Yeah.
Ms. Mamela, did you ever receive yourself a copy of the contract after it was signed?
I do remember that. I think during the France took SAT to court. So we had to get the copy. It's just that I don't remember where we got the copy from. But we had to get all those copies, as much as we had to get the tender documentation from the CFST to respond to National Treasury, to respond to Mr. Dumieni, who was also asking questions about the award and stuff, yeah.
So you do recall at some point, because that litigation was actually quite shortly after the award, wasn't it?
It was shortly after the award, yes.
So it would have been around the time of the conclusion of the contract then that you did get a full copy?
It will have been around the time when we were preparing to defend the matter at court.
Thank you.
Yes.
I'd then like...
sorry, Ms. Ufmeya. I just... because this is written, it's still about AR and JM. Can I direct you to Exhibit DD B? Sorry, DD 25B. My.
Just repeat what you are saying without when you do that.
I want to.
Part of what you say we can't hear.
Exhibit DD 25D, that's my file, Chair.
Yes. What do you want us to look at?
I would like us to go to page 487 of that file.
Yeah. Is that in response to respond to a question?
I'm trying to see what is this documentation.
Which documentation?
The one in page 487, Chair, of DD 25.
It's an annexure to Ms. Mbeki's affidavit.
Is this part of the contract or can we?
No, it's not. Ms. Mbeki explains what it is at page 469, paragraph 17. She says, in the
469.
meeting of 3 June 2016, the team discussed the binding agreement to enter into definitive documentation. The said agreement is dated 3 June 2016 for ease of reference, see Annexure 3.
But why do you want us to go
Yes.
there, Ms. Memela? Because we're still with Mr. Kenny's affidavit.
No. I was just like still. My mind is still in the AR contract.
Yeah, okay.
They're being
now.
signed, and then I see this one.
Okay, let's, Ms. Hofmeyer is about to finish her questions. Let your mind come back.
Okay. Okay, sorry, Chair.
Yeah, okay.
Ms. Mela, I wanted to draw your attention to one of the provisions of the signed agreement, which you've confirmed for us you did see at a point when the litigation was being pursued by Air France. And you'll find that in DD 22F at page 2325.
Yeah.
It was the one I drew your attention to a moment ago. This is a clause that we dealt with in Mr. Human's evidence. And the clause that's relevant is clause 4.26 at the bottom of that page. And I would just like us to look at it because there are going to be a series of questions that flow from it. So it'll be useful just to have it in the front of our minds. What it says at 4.26 is, prior to the commencement date, JMAAR will invoice SART for the deposit.
I'm sorry.
Apologies,
are
Chair.
you at 2325?
I'm at 2325 and I'm reading from the last clause on that page,
Oh,
clause
okay.
4.26.
Okay.
Apologies.
Actually, we may have, oh, no, okay, let's continue because I think you were close to finishing.
I am indeed.
I'm not putting pressure
No,
on
no, no.
you. It's just that I was thinking whether there should be an adjournment, but
Yes.
let's finish first and then we
I
can
think
take
Ms.
from there.
Mbantwa would like
Ms.
to say
Mbantwa,
something.
would you like to say something?
No, not really. It's a personal thing, Chair. I
Oh.
wanted to just get a quick comfort break.
Oh,
I can't
okay.
do just
No,
now.
that's fine. Let's do that. So 10 minutes?
Yes.
Is 10 minutes fine?
It is more than enough. If you
It's
like
more
to
than
say
fine. Okay. Let's just say 10 minutes. So we'll resume at 15:15.
Thank you,
We
Chair.
adjourn.
All rise. All rise.
Yes, Ms. Hoffman.
Thank you, Chair. We were going to look at clause 4.26 on page 2325 of Exhibit DD22F. And because it's going to frame the next set of questions, I propose just to read the clause into the record. It provides the following. Prior to the commencement date, JMAAR will invoice SART for the deposit. SART will pay the deposit by way of irrevocable standby letter of credit from a bank acceptable to JMAAR and in a form agreed to by JMAAR. The parties agree that, subclause 1, JMAAR will have the right to set off any SART invoices not paid by its due date against the deposit. And subclause 2, SART shall, when necessary throughout the term of this agreement, replenish the deposit to maintain the amount invoiced by JMAAR prior to the commencement date. And 4.26.3, at the time of expiration or termination of this agreement, JMAAR will arrange for the release of the deposit to the extent that SART has paid all outstanding invoices. Ms. Mamela, you had a copy of the agreement at the time around which it was signed in the litigation. Did you have cause to look and consider this particular clause?
No, I didn't, Chair. I do know that from the that first meeting that I was referring to, the deposit was part of the conditions precedence between both parties. I mean, there was conditions precedence for SART as well, and as much as there was conditions precedence for the other party. So that was discussed on the first meeting.
But what was concluded was actually an arrangement whereby there would be an irrevocable standby letter of credit from a bank which would serve the purpose of the deposit. Isn't that correct?
According to the contract, yes, that's correct.
Yes. So then I'd like to just follow up on what happened with the payment of cash to AAR. Because what starts to happen in September of 2016 is that it appears that AAR starts to raise the issue of why it hasn't been paid a deposit. Do you recall that?
I recall, Chair, that they were not paid because SART was not in a good financial space, I think. So SART couldn't pay that. But I think the person who can answer that better would be the CFO of the company.
Well, there's quite a bit of correspondence involving you, so that's why I'd like to take you to that.
Okay.
And we can commence that in your file DD25B at page 649.2.
Page
649.2.
Yeah.
Okay, so 649.2, the first of the emails in this email chain, is in the second half of that page.
Yes.
It's an email from Ms. Pumeza Nansi. Who was she?
Ms. Nancy Chair was this former group chief financial officer of SAA.
Chair, you'll recall we had Ms. Nancy give evidence in June of last year before the Commission.
I was trying to remember
Remember.
the name is
Indeed.
the same. Yeah,
It
okay.
is indeed. And she sent an email to Mr. Michael Klein and Dev Araya, and it's copied to yourself and Mr. Musa Zwani. Is that correct?
She sends the email to Michael Klein, being the from what do you call this? It's the department that reports to finance from SAA, but just for Treasury Department. And then Mr. Dev area. I thought I should explain, since Ms. Hofmeyer wanted me to explain also Pumeza Nancy, that I should explain others as well, their role. And then Dev area is the CFO, was the CFO of SAT.
And then it's copied to yourself and Mr. Zwani. Is that correct?
That's correct.
And it's dated the 29th of September 2016.
Yes, that's correct.
And just to read into the record what Ms. Nancy says on that email, she says, "Good day. My understanding from the discussion that I had with the ACEO, I take that to be acting CEO,
Yes.
AAR now wants us to pay them 1 month deposit, which is equivalent to $1 million US. We can make the payment if you can facilitate the paperwork. As I understand that it is part of their policy that we should pay a deposit, which we did to the previous service provider." And then the next email in response is from Mr. Klein to Ms. Nancy, Mr. Area, and copied again to yourself and Mr. Zwani. It's on the same day, a little bit later. And Mr. Klein says, "Dear all, please discuss with AAR the possibility to replace the cash security deposit with a bank guarantee or standby letter of credit sometime in the future if it is not currently a clause in the agreement. It is a standard clause we have introduced into aircraft lease agreements as well." And then if you go back a page to page 649.1, you'll see your response to that group of recipients. Could you read into the record what you said in response to Mr. Klein?
From page 649.1.
Indeed.
Yes, at the bottom there.
Yes.
We will do, Michael. All I remember during the negotiations, we fought against this, and they confirmed that this is part of their policy. Unfortunately, we couldn't walk away and automatically disqualify them because the deposit or lack thereof was never part of our tender requirement. So we can safely say that Air France 1 would have been better deal, as this deposit is still part of the price in the contract. We still stand to save a significant saving out of this. Thanks, Michael.
Ms. Pamela, why didn't you respond to Mr. Klein and say, no, it's not a problem. The agreement does actually only make provision for an irrevocable standby letter of credit?
Why didn't I say, sorry, can you repeat that?
Because what Mr. Klein is saying is he's saying we're now being asked to pay cash of $1 million US. And he says to you at page 649.2, "Please discuss with AAR the possibility to replace the cash security deposit with a bank guarantee or a standby letter of credit sometime in the future if it is not currently a clause in the agreement," right? And your response to him was reflecting on the negotiations and that you'd fought hard on it.
The first one before the negotiation, it says we will do, Michael.
Indeed.
Yes, meaning we'll check what she said it should be checked.
Oh, so you did check, did you?
No, I'm saying, you're saying, why didn't I just, so I'm saying, Chair, the response to Michael was, we will do, Michael.
Yes.
Then I just went on to explain to him that, as I was saying, it was part of the conditions precedence. I remember this because it was discussed on that meeting, the first meeting. So I just went through that because he's sitting at Treasury at SAA. That's why I had to explain who is who, so that he understands the background.
Okay.
Yes.
Thank you. So, sorry, I did misunderstand. So then did you go and check the agreement?
I will not remember right now. Remember that.
But
when I
hang on one second.
Okay.
But is my understanding correct that what you have just said is that you were saying you will check the agreement?
I said we
Yeah,
will do.
Yes.
We will do, that involves the
Checking
CFO
the agreement.
of SAT, because like he said we must check with AR if the replacement of, and that's the financial topic. Yeah, so my understanding that will be done through finance, not me checking directly. So I'm not sure if I checked that.
Sorry, but I understood you to emphasize a moment ago in response that you said we will do that.
Yes, like I was reading that because you were focusing on the negotiations only. So I'm saying like I did respond to Michael because you were saying why didn't I respond and say this? So I'm saying I did say we will do, Michael.
Indeed. So
Yes.
what did you do to follow it up?
I don't remember.
You don't remember?
No.
Okay. There seems to be a comment.
Oh, Ms. Mbanga, you had your hand up. I didn't see.
Sorry,
No, I
Chair.
didn't see, but okay, yes.
Yeah, sorry, Chair, that I should have voted for you. No, Chair, I'm just correcting. What I think is going to confuse Ms. Memela. What Ms. Hofmeyer started by doing was to read from volume DD 22 2325. And that is the agreement. So she directed our attention to clause 4.26, which is already an agreement that is there. And that agreement does have a clause that says, prior to the commencement date, JM/AAR will invoice SAT for the deposit. SAT will pay the deposit by way of an irrevocable standby letter of credit from a bank acceptable to JMAAR and in a form agreed to by JMAR. So that clause is there. Now, this other document, which is Exhibit DD 25B, Ms. Memela's bundle, if I could call it that. There is that letter in...
Next time you check, just check and stop speaking and come back to the mic and speak, because when they transcribe, there'll be a lot of inaudible during the time when you were looking at the file. So then not everything you say will be captured in terms of the transcript.
Thank you.
Okay, all right.
Thank you.
Continue, yeah.
Then in this bundle, DD 25, page 649.2, there is that email from Michael Klein dated the 29th September, which says, please discuss with AAR the possibility to replace the cash security deposit with a bank guarantee or standby letter of credit sometime. So what I'm trying to point out is that clause 4.26 already provides for substitution of a cash security deposit with a bank guarantee or a standby letter of credit. So why I'm scared that Ms. Memela is being asked to answer is because what Ms. Hofmeyer is saying she should have checked is something which is already in that agreement. It is there. I just do not know why the parties had this engagement. Maybe the party who asked was not aware of the provisions of this contract.
Yes, I think let's leave Ms. Hofmeyer to
Thank you.
conduct the questioning. Yeah, okay, all right.
So Ms. Pamela, I understand your evidence to be you don't recall what you did to follow it up. Is that right?
I don't recall what I did to follow that up, but I do know that there's finance that is supposed to be dealing with this thing, which my understanding is that the reason why, at the first place, Ms. Pumeza Nancy was involved is because like, she was the group chief financial officer, whom is the one who actually approves from Treasury what should be paid to which supplier.
So at no point after these emails in September well, let me ask it differently. Did you at any point after these emails in September of 2016 go and get the contract and look for the provisions in relation to the deposit?
I don't remember, Chair.
Well, let's go to what then happens, because there's a jump in time to about April 2017 in the correspondence that we have in relation to this matter. And you'll find that in your bundle DD 25B at page 650.
Yeah.
Now, at 650, there is an email there from Makgotso Mosese. Who is that?
I'm sorry, at what page?
Apologies, Chair, we're at 650.
Okay.
And I'm starting at the bottom of the page to follow the chronology.
Chair, can we, before we get to Makgotso, start from the email from AR?
Oh, over the
before
previous
Makgotso?
page, yes, certainly. Let's start at 651.
Yes, there's that email, Chair, where Makgotso then is, I guess, is following up on.
Okay.
The email is coming from Mr. Matthew Dobbs from AR, returned to Makgotso Mosese. Ms. Hofmeyer asked me who's Makgotso. Makgotso is management accountant of SAT from Finance Department. Dear Makgotso, hope you are well. In attachment, you will find the statement of account. We have 3 invoices overdue. Could you please have a look and let me know if you need additional info from us? In addition, you will find the late fee calculation sheet. I remain at your disposal for any additional info you need. And then Makgotso responds, adding Wellington, who was the business analyst.
Ms. Mamela, just to interject there, I don't think it's a response to Mr. Dobbs. I think what Makgotso Mosese does then is, it's an internal correspondence. Is that right?
Yes, that's why I said like she followed up, or maybe sending to the internal people,
Yes.
based on Mr. Dobbs' email.
Yes, and what does she say?
She's writing to Wellington Yusra from Finance as well, who's the manager there. Hi Wellington, AR is inquiring about the security deposit invoice that we were contractually supposed to pay. The payment never happened. Wellington, I believe the expense authorization was last with you. I don't quite remember why the payment was never made, but I think it had something to do with Treasury. Please remind me of why we never made this payment so that I can give AR an appropriate response. And then Dev Area, the Chief Financial Officer, responds on the same date.
And Ms. Mamela, he now includes you in the response. Is that correct?
Includes me in the response, and then he adds Bongile Mthembu. Hi Makgotso, please refer the query to Nontsasa and she will respond directly.
And then your response is at the top of the page. What did you say?
My response at the top of the page. Dear Makgotso, according to the contract we have with AR, we're actually supposed to have made a payment for security deposit upfront before they ever started providing services for us. That was conditions precedence. What happened then, we negotiated with them to pay 1 month upfront instead of the whole 3 months security deposit. We again negotiated with them to only charge the remaining 2 months by including it to the normal invoice and spread it over 6 months. This exercise was supposed to have happened 2 months ago already. I'm not sure why they are not paid.
Ms. Mamela, what I'm interested in there is your introductory words. According to the contract we have with AAR, we were actually supposed to have made a payment for security deposit up front before they even started providing services for us.
Yeah.
That's not what the contract provides.
On the conditions precedent, Chair, that's why I said, the discussion there was that the SAT will pay 3 months upfront, but through the negotiations, they were able to agree on certain changes, as it is stated in my email.
Yes, why would you say that the contract that was concluded with AAR required a payment of a deposit up front when that is not what the contract provides?
Okay, can we go to check, before I answer this question, because I just want to check what is in the conditions precedent. I will direct you just now.
Okay.
Yes. Okay, Chair, the page 2327, DD 22F. Of
Exhibit
human.
DD 25.
22F.
Is that the what's written on the spine?
Mr. Human.
Oh,
Yes, Chair. On
Okay.
the contract of AR.
22F.
22F.
Indeed, Chair.
Yeah, okay.
Yes.
Yes, you. What is the page number?
The page number is 2327.
Okay, 2327.
Yes, Chair.
Okay.
It says JMAR obligation to provide the services to SAT is conditional upon fulfillment and delivery to JMAR of the following conditions precedents. 6.23.1, payment of the deposit. And then it states other conditions precedents. I'm trying to remember where was the 3 months, because I remember there was a discussion of 3 months.
And if there was 3 months, what was going to be your answer?
Okay, the question from Ms. Hofmeyer was that why did I say it was 3 months when the contract does not say that?
No, that wasn't the question.
Oh, okay.
The question was, why did you say, according to the contract, you had to make payment of a security deposit when all that the contract required was a standby letter of credit from the bank?
Okay. Chair, can I read again and explain my interpretation?
Yeah.
According to the contract we have with AR, we were actually supposed.
Where are you reading from?
I'm reading the same email that Ms. Hofmeyer is reading.
Yeah.
According to the contract we have with AR, we were actually supposed to have made a payment for security deposit upfront before they even started providing services for us. What happened then, we negotiated with them to pay 1 month upfront instead of the whole 3 months security deposit. So the negotiation happened before the contract was concluded.
Ms. Pamela, we're at cross purposes. What I'm interested in is the contract, clause 4.26 that we looked at, does not require any money to be paid by SART to AAR. What it requires is an irrevocable standby letter of credit from a bank, in respect of which drawdowns can be made. But rather than saying that, Ms. Mamela, in your response to the queries from finance, you said, according to the contract we have with AAR, we were actually supposed to have made a payment for security deposit up front before they even started providing services for us. I understand the negotiation is about whether it's 1 month or 3 months. But the point I'm interested in is, why would you say that it's necessary that a payment be made for the security deposit when all that the agreement, if I could finish my question, when all that the agreement required was a standby letter of credit to be provided?
But you are reading from pricing and payment versus the deposit. The deposit share was the payment that was going to be made upfront.
Where in the agreement does it say there needed to be a payment of a deposit?
That's where, Chair, I had taken you to the conditions precedents, page 2327.
2327?
Of exhibit 22F of Ms. Duman.
I'm sorry. 237 of 22F.
22F, yes.
Yeah.
Yes, Chair.
2327, I'm there.
Yes, and then there is provision 6 that talks to conditions precedents and conditions subsequent.
You are referring to 6.23.1, payment of the deposit.
Yes, Chair.
Okay.
So Ms. Hofmeyer is mixing these provisions. the one in four is talking about pricing and payment.
Yes,
Towards
let's
the
look
contract.
at what,
And I'm referring, like in my email, it's referring to the deposit that SAT had taken time to pay to AAR. It's not referring to
But-
pricing and payment.
But go to clause 4.26, Ms. Memela, at page 2325.
Yes.
It says, prior to the commencement date, JM/AAR will invoice SAT for the deposit. And then it says,
Where are you reading, Chair?
clause 4.26 at page 2325, same bundle,
Yes. 3325.
2325, yeah.
Yes, sir.
Okay, the clause is the last clause on the page, 4.26. It says, prior to the commencement date, JM/AAR will invoice SAT for the deposit. Then it says, SAT will pay the deposit by way of an irrevocable standby letter of credit from a bank acceptable to JM/AAR
Yes.
and in a form agreed to by JM/AAR.
Yes.
So this doesn't mean, as I see it, that cash was required to be paid.
No, yes,
The
Chair.
submission of a standby letter of credit from a bank acceptable to JM/AAR would be regarded as that deposit.
Yes, Chair. But what I was explaining to the finance team was that before the contract was concluded, the AR had put on the negotiation table on that first day that we were supposed to have made a payment for security deposit up front, and they said that was their policy when we stood up to that. I think there's somewhere where I'm actually explaining. I think it's in the where I'm explaining to Michael Clay.
But
yeah.
do you accept, now having looked at clause 4.26, even having regard to the conditions precedent, clause 6, that in terms of the agreement, SAT was not required to pay cash, so to speak. It needed to simply provide a standby letter of credit from a bank acceptable to JM/AAR.
Chair, where I'm responding that I'm not sure why they are not paid. I was responding to Mahotso's email to Wellington where she's saying, Wellington, I believe the expense authorization was last with you. I don't quite remember why the payment was never made, but I think it had something to do with Treasury.
But that's the point that Ms. Hofmeyer is pursuing, to say, why is anybody talking about, as I understand what is being said in the emails, payment as if it's payment of cash. I'm saying cash, including electronic transfers. Whereas what is all that SAT was obliged to do and all that JM/AAR were entitled to was simply a standby letter of credit from a bank that was acceptable to them.
Okay, Chair, I don't remember, but like my understanding is that finance would have the copy of the contract to understand like what are the terms of payment.
Yes, but what I'm asking is whether, okay, no, maybe not now.
Okay.
Do you accept that that is what I've just said is what the agreement required?
Was required.
Do you
yes.
accept that? Had that always been your understanding, or was your understanding at some stage different?
As I said, Chair, that like the last time I had talked about this contract, the first time, it was that first day when we were negotiating, and I remember like the discussion around conditions precedents
Yes,
took long.
but I'm not talking about before the conclusion of
Oh,
contract.
okay.
After the contract has been concluded, had your understanding been different in regard to such obligations about the deposit?
After the contract had been concluded, Chair, I doubt that I had gone back to the contract, except the time when we were preparing to go to defend SAT at court.
Yes. So you are not sure what
I'm
you
not
may
sure.
or may not have known at the time?
Yes.
Okay, all right. Ms. Hofmeyer, I think the hand has, I think it's been cleared. It's not cleared. Okay, Ms. Mbanjwa.
Chair, just before I hand over to Ms. Mbanjwa, I would just like to raise a caution.
Yes.
What would diminish the weight of Ms. Mamela's evidence after this point is if in any comment or objection that Ms. Mbanjwa raises, she effectively leads Ms. Mamela to an answer. And it's just something that I raise because it ultimately has an impact on the weight that's afforded to Ms. Mamela. So I would just suggest to my learned friend that she not lead Ms. Mamela in any question that she now, or comment she wants to raise.
Yeah.
Thank you, Chair. The reason why I'm raising a hand is because I believe there is an error of understanding that involves Ms. Hofmeyer and Ms. Mamela. I'm not going to raise it now. I'm just noting it because when I re-examine, I will re-examine at exactly this point. And where is that error? The error is the fact that what is happening is two separate issues are being conflated. One is a condition precedent, which is either a letter of guarantee, which would be a deposit that stays there. And then when the expenses come, they would then be debited against that account. And then this is being conflated with the fact that insofar as the deposit is concerned, a letter of guarantee would be sufficient. But what the rest of the emails talk about, they have moved away from the letter of guarantee. They are now talking about expenses that have already been incurred. But I will clarify that.
I think, Ms. Mbanjwa, that's the kind of thing Ms. Hofmeyer was talking about. That you raise an issue which may be seen as explaining to Ms. Mamela, you might not be intending to do that, but she may have that benefit in answering. So maybe, because it's important that her evidence be given the weight that it deserves, maybe keep it for your re-examination and let her answer to the best of her ability. Nobody is suggesting that you are doing anything deliberately, but sometimes when one is trying to raise points, this effect could arise.
But Mr. Chair, what I just want to point out, the way I understand proceedings of any nature, if you are representing a party and a question that is confusing is directed at the party, you can stand up and say the question is confusing. I do not think, Chair, the test is the test of what Ms. Hofmeyer, with due respect, has said. She said, if I'm standing up to point out that she herself is asking a confusing question, that would then mean at the end of the day, when evidence or credibility of that witness is being judged, it will be against her. That is not the test. The test would be, was the question confusing? Because if the question was confusing, then it means we are in the right.
No. If you believe the question is confusing, it's legitimate for you to raise that. But even from your own explanation, it seemed to confirm my own understanding, which was that I certainly didn't see it as confusing. That doesn't mean you didn't see it as confusing. You may have seen it as confusing. But
no, thank you, Chair, again for your patience,
okay,
but I will take it up in re-examination.
Yes, okay.
Chair, Ms. Mbanjwa, in her comments a moment ago and seeking to clarify the confusion, made a statement that these invoices were related to expenses. That is not the case. And the reason for that is because the way that the deposit worked under the agreement, I'll take you to the provision now. Just have to find it again. Was as follows. You find it at the agreement. It's tucked away. This is a very complex agreement, but it's at page 2335 of DD 22F.
At 2335, yes.
Yes. You see, that is where you find the definition of deposit. You'll see against 3, it says deposit equal to 3 months' revenue to be reviewed and adjusted annually in line with fleet growth and annual escalation. So, Chair, the whole structure.
Sorry, where are we reading, ma'am?
Oh, sorry, 2335.
2335.
It's the part of the agreement that gives the definition of deposit. And it's the place I think you were looking for earlier, Ms. Mamela, because it refers to 3 months. The deposit is equal to 3 months' revenue to be reviewed and adjusted annually in line with fleet growth and annual escalation. So what happens is when you read the conditions precedent, clause 4.26, and the definition, and this is played out in the invoices that then come from AAR, so I'll go to the facts in a moment. It is a requirement of this agreement. And Ms. Mamela, I'm putting this to you so that if you have a different understanding, you can clarify that for the Commission.
Where are you still on 2335?
No, I'm now drawing the condition precedent, the definition of deposit, and clause 4.26 together, because you have to understand the agreement in its totality. And if you have a different understanding...
Hang on, Ms. Mamela.
Chair, I'm just
getting
saying,
confused.
I'm not getting confused. I'm just saying maybe it will brush my ego a bit if Ms. Hofmeyer would say, okay, the 3 months deposit that you were referring to on your email, I'm sure this is the one.
But she just said...
No, but she didn't say it the way I wanted
No,
her
but
to say
she is on a certain point. She is on a certain point. She's on a certain point.
Because I said it, and
hang on, Ms. Wimmel. She is on a certain point that she regards as relevant for now. But she realizes that it refers to 3 months and remembers what you said earlier on.
Wow.
And says in passing, because she's on a certain point, maybe this is the clause you had in mind. That's what she said.
So
what did you want her to say?
No, Chair, I'm just, you know.
Okay, all
I don't
right.
know how to explain it.
Okay,
just,
no, that's fine.
Let
Ms.
me leave
Hofmeyer,
it. But
I
I was just hoping that she would have
Continue.
said, you know,
Okay.
this
Okay.
is what we're talking
She's on
about.
a certain
Now I
point.
understand.
No.
where you're
She's on
coming
a certain
from.
point. She might or might not come back to that point, but she's
Okay.
on a certain point that she's busy with. Ms. Hofmeyer?
Yes.
Chair, what I would like to do is explain what the understanding of the conspectus of this contract is so that Ms. Mamela can offer a response. The contract works as follows, as we read it. It is a condition precedent of the contract that a deposit be paid. It is then provided in clause 4.26 at page 2325 how that deposit is going to be paid. And it's going to be paid prior to the commencement date. So it's consistent with the conditions precedent provision. And it says prior to the commencement date, JMAAR will invoice SART for the deposit, and SART will pay the deposit by way of irrevocable standby letter of credit from a bank acceptable to JMAAR and in a form agreed to by JMAAR. And when you go to the definitions for what that deposit will comprise, you're told that it will be calculated on the basis of 3 months' revenue, and it will be reviewed and adjusted annually in line with fleet growth and annual escalation, which in the conspectus of the contract makes absolute sense because it's standing there as a guarantee against default and late payments by SART. That means annually it must be reviewed because over the 5 years of the contract, it may well have to be increased to provide the same level of security against late payment by SART. Ms. Mamela, that is what we understand the agreement to mean, and I'd like to have your comment if you understand it in any different way.
I have no comment, Chair.
And then, just to confirm, I said I'd go to the facts because that's precisely how AAR invoiced for it, albeit that they were now wanting cash. They didn't want a standby letter of credit anymore. You'll find that at DD 22F, is it? F, and that is at page 2403.
2203?
2403.
2403.
Oh, 2403.
Yes.
Yes.
This is the invoice that AAR sent to South African Airways Technical. And it's just around the time of this communication in 2017 because it's dated the 18th of April 2017. And you'll see that the total amount of this invoice is $4,382,224.71. And the description that's given of it is security deposit, dash 3-month minimum flight hour billing, April 2017 minimum FH billing, and the indication is that the monthly billing was US dollars $1,460,741.57 times 3. So that's how they calculate the 3 months that they are now requiring be paid. So back to the questions, Ms. Mamela. What then happens is in May, there's a follow-up. Apologies, I need to have a DD22G in front of me. The challenge that SART was facing at that moment was a cash flow problem. And that's evidenced from the communications that we'll go to next. And Ms. Mamela, what I want to put to you for your comment is the following. The difference for SART between a standby letter of credit from a bank and actually paying money is that that has an immediate impact on cash flow. Do you accept that?
Okay, Chair, that will be answered by finance that made this payment.
Well, are you sure that it's something you can't answer? Because it seems to me that it would be quite logical that if you pay somebody with cash, logically, after paying somebody with cash, you are left with less cash. Your balance goes down, and if you or your company is going through difficult financial times, you may be needing the cash. Are you sure it's something you can't answer?
No, Chair, I'm not trying not to answer anything, but I just feel that maybe if I was the one who was approving the payment, then like it would have been logical for me to answer. But
yes,
then I would answer in a general statement that, of course, that would what it means.
Yes.
To a lay person who does not have a financial background.
Ms. Bandra.
Thank you, Chair. The question is unfair to Ms. Mamela because the premise is incorrect. If a person says provide a letter of guarantee of credit, it does not necessarily mean that that letter of guarantee of credit is not underpinned by cash. Take, for instance, my example I'm going to give. I work as a conveyancer. If a client is buying property, and then before the transfer can take place, the seller of the property is going to want guarantees that on the day of the transaction of the sale. Do you want to
I
say
think you can deal with it in re-examination.
Thank you. As
Yeah.
long as it is accepted, it's unfair for her. Thank you.
Let's go to DD 22G to pick up where finance starts to raise with you their concern about the cash position.
We are at 5 o'clock.
Right.
I would prefer that we adjourn when you are done, but we are at 5 o'clock, and maybe we should adjourn and you finish tomorrow
Chair,
morning.
I think it may be safer because any estimation of time that I give you
is difficult.
unrealistic.
Yeah.
So this is an aspect to conclude the payment,
Yes.
and then there will be a few concluding aspects. So we should just do it tomorrow if that suits.
Yes, yes. But of course, we have to start looking, we should talk about what arrangements can be done with regard to Mr. Nzeku.
Yes. Chair, apologies, Chair.
Because I think if we are not going to finish with him, if we will be able to start and not finish with him, and of course we should be able to start. But if we are going to be able to start and not finish with him, it may be that we should just arrange another date when he can come and we deal with his evidence.
Chair, I did have a brief opportunity to speak to his legal representatives over the break. They indicated to me that they may have a proposal that will facilitate his evidence. I think the chances are extremely unlikely that we will start Mr. Nzeku tomorrow.
Yes,
especially
yes.
because of the time that is indicated and your limitations tomorrow for how long we can sit.
Yeah.
So it would be my proposal that I conclude briefly in the morning, we hand over for the re-examination, and then I will have discussions with the legal representatives of Mr. Nzeku immediately after this hearing adjourns, and then I can come back to you with proposals for when he may be able to return.
Yeah.
Of course, that will have to fit in with the schedule, but we will be able to discuss that.
No, that's fine. Ms. Mbanjwa, it seems that we should adjourn for today. Have got anything to say about that?
No, Chair, I quite understand that we are in your hands. I just wanted to voice a difficulty I may have after tomorrow, Chair. I have a part-head trial in the Magistrates' Court. Unfortunately, on Thursday, I have to attend to that part-head trial. So I'm just saying I do not know what arrangements, but I do not want to inconvenience the Commission by just jumping this thing on the Commission tomorrow.
Yeah, well, tomorrow we won't sit the whole day because I will have to leave tomorrow after lunch. It may well be, I'm not sure about, it may well be that we can only go up to 1, or it may be before 1, maybe after 12, I'm not sure. So, and on Thursday we won't sit because I won't be available. So we'll use the time tomorrow that is available, and if we do not finish, I hope we finish, but if we do not finish, then we'll arrange for some other time. But I'm hoping that we can finish, but it has not been easy to estimate time. So if your concern was about Thursday, that should not be a problem.
Thank you, Chair.
Yeah. Ms. Memela, you understand you you were part of the agreement that tomorrow you are still available.
Chair, I was just going to raise something which I'm sure I could have raised it through my lawyer. I was going to ask because Ms. Hofmeyer, as much as she thinks I'm the one who actually delays this, once she's given tomorrow morning, I think we'll take the whole day again. So I wanted to check if I can't give her crisp answers and then we're done. I won't take long, and then so that we know that tomorrow we start with...
We can do with a firm undertaking to give crisp answers, Ms. Mamela.
I undertake, Chair.
Yeah, we'll see. If you give crisp answers, it will help.
I will do it.
Yeah, it will help. Okay, I think we'll have to adjourn. And I think we must start at 10.
Certainly, Chair.
Yeah. Okay, we'll adjourn then, and tomorrow we'll start at 10. We adjourn.
All rise.
We are not taking... Go. Hey, I will die if I have to go through the information today and come back tomorrow.
So that we don't die.
Yeah.
Almost wrong.
Yeah.
This is our book about it.
No, I'm telling you, I'm not a problem with land. Send you to go with the info.
No, yeah, because I let's do it in the morning. Icon is only this only.
AP, the one
It's
with
only this contract, otherwise the rest is fine.
Okay, so are we going to ask for this?
Yes, we have to ask for this. But we don't have give it to me.
Yeah, it's so long but you know.
Please, don't
Because I've let her down. And thinking I don't let him go with him, only was and questions.